Good morning. Is everyone here? Okay, see everybody's cameras popping on now. Thank you. Okay, so first question, do we have a court reporter?
Yes, I'm here.
Okay, good morning, ma'am.
Good
I'm going to
morning.
make it clear for you. I'm going to call the case and then get everybody to do announcements and then we'll get started. Um, Madam Court Reporter, this is going to be a TRO hearing in the matter of ATL Custom Spec versus Stephen Edelkind. Case number is 25CV013591. Can I please get announcements from counsel, starting with counsel for the plaintiff?
Good morning, Your Honor. Ted Ader, counsel for the plaintiff. We are present this morning.
Thank you, sir. And counsel for the defense?
James Merritt, Your Honor, for the defendant, and I believe my associate, Rebecca Regas, is also on today.
Yes, and she is who appeared previously in this matter.
That's correct.
Thank you. Okay, so I see we have some other people here, I assume, besides the court reporter. Those might be witnesses or people involved. Is that correct?
Yes, Your Honor. For the
Okay.
plaintiff, we have two witnesses today.
Okay. And tell me, so procedurally, where we were previously is there was I think procedurally, this case was a little bit of a mess in terms of who had gotten served and when and whether service was proper and all those circumstances. And then it looked like there was service. And so I ordered a default judge, or I ordered someone to file a default judgment. And then the parties came to a scheduled hearing and they were able to work out sort of the status of the case to get it where it is now, which is still alive. And now we're looking at the merits of the case. And so the purpose of today's hearing was the actual original filing by ATL Custom Spec was a request for a TRO against Mr. Edelkind based on allegations that he was interfering with the construction project next door and or with the employees who were appearing at that location. And so that's what I understand we are here about today. And is there anything else that I'm not capturing that you were expecting or hoping to address today, Mr. Ader?
No, Your Honor, I think you scheduled or kind of framed that in nicely. The only other issue in the complaint was a request for cancellation of an easement. After discussing with opposing counsel, we've established the easement is actually not held in the name of the defendant, but the defendant's spouse, so there's not privity for this particular case. So we're withdrawing that at this time. We're focused exclusively on the potential damage to the property and then harassment or assault of the um, principals or agents of the plaintiff that are present on the property or potential buyers.
Thank you, sir. And Mr. Merritt, what are your thoughts of anything else other than what I've outlined? And then Mr. Ader's note that that they have withdrawn the easement claim.
Well, Your Honor, I mean, I agree with everything Mr. Eder said. I would say that for the same reason, it is our position and our understanding that they would also be withdrawing the quiet title claim for the exact same reason. Our client is not on the deed for this specific property, and he's made no claim to have any title to the petitioner's property. So I don't think there is a quiet title action. I think the only issue here is the injunctive relief. And so, yeah, so for today, I believe the only issue here is count one for the temporary restraining order under 9/1165B. And I would just say as a housekeeping matter, I'm not really sure which witnesses are on, but I would request, I'd like to invoke the rule of sequestration and then request that they be put in a breakout room until they're called to testify.
Okay. Mr. Freehoff, I don't know if you heard that, but if you could please create a breakout room for, let's see, Mr. Edelkind is entitled to be here as a party. So who are your two witnesses, Mr. Ader? And I'm just going to exclude whomever is not going to be your first one.
Our first witness will be Chris White. She is the principal and a party in this case, so she's entitled to be here as well. Our
Okay.
other witness is Jeremy Jones, is an internal designer. He's worked on the project and has been present during both an altercation as well as a police call to the property.
Okay. So, Mr. Jones, if you can hear me, sir. Okay. Mr. Freehoff, if you could create a breakout room and invite Mr. Jones to it. Mr. Jones, we're going to sort of kick you out of the room, virtually speaking, if you wouldn't mind. And then hopefully we'll be able to bring you back. Now, technologically, I am not the most savvy. And so if you get kicked out or just kicked off entirely, just rejoin the same Zoom link that you previously had and we'll get you squared away. Okay. And then the last question I have for Mr. Ader and Mr. Merritt before we begin substantively is it sounds like you guys have spoken and tried to work through some of the issues to at least narrow some of the issues, and I very much appreciate that. Has there been any ability to work through what an agreed TRO or something would look like in terms of Mr. Edelkind would agree to X and the ATL spec would agree to Y?
Yes, Your Honor, we proposed one last week. We never heard back from the defendant until yesterday, when they said that they didn't think we had enough time to establish an agreement.
Okay, understood. Okay, well, then let's go ahead and get started. So I want to give you as much time as I can. Ms. Samuels, did you need something?
I just need to know if the attorneys will be splitting takedown today.
Always take care of your court reporter.
Yes, we've agreed to split takedown.
Correct.
Okay.
Excellent. Okay,
Oh, sorry, I
That's
do
okay.
have one other question. I'm sorry, Chris W. The last name for Miss W. I don't-
White.
White. Okay. Thank you so much. That's it.
thank you. Mr. Ader, you may call your first witness.
All right. Uh, we're gonna go ahead and call Chris White at this time.
Yes,
Ms.
I'm
White,
here.
will you raise your right hand? I'll swear you in. Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. You may lower your hand. Go ahead, sir.
All right. Good morning, Chris. How you doing?
Good morning.
Would you please state your name for the record?
It's Kristen Marie White.
Thank you. Could you please explain your professional background for us a little bit today?
I'm a residential certified general contractor in the state of Georgia. I'm also a structural engineer by trade.
All right. And what does your business typically entail?
It's renovation of older homes in the Atlanta area as well as new construction development for customers, private.
So it's safe to say you're a home builder.
Correct.
Okay. Have you ever been involved in a legal dispute before meeting Mr. Edelkind?
No, I have not.
And how many years were you practicing or building houses before this current situation erupted?
I've had my company for 15 years and was another 3 years in prior to having my own company.
All right. So it's safe to say that over the previous, decade and a half or so, you hadn't had any issues with any neighbors.
Correct.
Okay. How did you come to own the property located at 843 Yorkshire?
A real estate agent that I work with contacted me and said that the home was going to be coming on the market and asked if I wanted to purchase it for construction.
What condition was the home at 843 Yorkshire in when you purchased it?
It was dilapidated, had not been lived in for a couple of years. The older woman who owned it died, and no one had been in there, and so it was overgrown and had rat infestation.
Yeah. So it was essentially an abandoned property at that point?
Correct.
Okay. When did you meet the defendant, Stephen Edelkind?
Probably a year after purchase. We worked on the permit and I met him maybe on site in early 2024 when we started putting signage out and getting prepared for taking down the home.
Okay. And what was the initial tenor of that relationship?
It was normal. I introduced myself to all of the neighbors to let them know who I was, give them my contact information, what I was going to be doing, sharing the plans with them. So it was normal as it was with all the neighbors surrounding the home.
Right. And that's something you typically do in order to avoid any kind of disputes or conflicts with neighbors when you're building?
Correct. And I want to give the respect to the people because construction can be quite intrusive.
Understood. When did the relationship sour and why?
I believe it was after we did the foundation work, there was a 2 foot, what we call a rubble wall. It's stacked granite that fell into the property after 3 months of rain. It fell over into my excavated area, and he was aggravated about it and upset about it.
So about when did that happen?
I think it was in, I would say July of 2024.
Okay. Tell me about this retaining wall. Why do you think it collapsed?
It was not a structural wall. There was no footing or rebar or any type of structure to the wall. It was stacked granite boulders or rocks stacked together with some concrete in between them as just a divider between one area and the other.
Okay. And that retaining wall is located entirely on your property?
Correct.
All right, but subject to an easement, correct?
Correct. Yes.
Understood. What did you do to fix the problem after the retaining wall collapsed?
Within 24 hours, we shored up. I had excavated that side 5 feet from the wall, and I had shored it up. And then within 3 weeks, I believe it was, we had a proper wall built. I put footings in with rebar, poured concrete wall, put rebar underneath, the areas to be supported, and replaced the wall with a structurally sound wall. I had engineers involved with geotech as well as structural.
And you would consider that to be an improvement?
Absolutely.
How much did you spend to construct this new wall?
All in with backfill, probably close to $70,000.
Oof. What did you do to limit damage to Mr. Edelkind's property or I'm sorry, Mr. Edelkind's wife's property while you were constructing the wall?
We put up security fencing around the property with screening just to prohibit anybody from coming into the area that was being worked on, and notified him that we were going to do that to protect himself, his wife, and his dog from entering.
And was Mr. Edelkind cooperative during this period?
Not exactly. We had asked him not to park. He has a very long driveway and a garage at the back, and then he had an area in front of us. It's a 65-foot long wall, and we asked him not to park in that area just to allow us to work in the area and to remain stability of my side of the dirt and stuff. And he continued to park right there. After about 2 weeks, he just parked there every single day, and it was a battle for us to work around it and get it established properly.
All right. Did he often become aggressive during interactions in this period of time?
Yes, he was very angry and very boisterous about it.
And he's remained aggressive since that time.
Correct.
Has he ever spit at you?
Yes, he has a couple times.
Could you walk me through what happened?
Your Honor, I'm gonna object to the relevance of this. The only reasons that they are seeking a TRO as pled in the verified complaint is the threat of tearing down the retaining wall and the fence. That's it. It had nothing to do with behavior, stalking, harassing, spitting, assault and battery. I mean, there's a lot of tabloid pablum in the other allegations in the complaint. But under count one, for TRO, it is nothing more than the threat to injury to property rights. So I just don't know how this is relevant in any way to the standard of proof for a temporary restraining order.
Your response, sir?
Your Honor, I think it's important for the court to consider the totality of the circumstances. And I think whether or not Mr. Edelkind has assaulted workers who are working on the property, and specifically the installations that we pled in the complaint, is extremely important.
Well, let me ask you this to Mr. Merritt's point. If, as I understand it, the relief that you are seeking, although I understand the complaint itself, I think Mr. Merritt is right. It is, at least in the count, framed as prohibiting further compromise or interference with property ownership rights. But certainly I understood the larger request to be one that would be directed at Mr. Edelkind and directing him to stay away from the property and to no longer interact. That's what I understood the original request to be. Is that roughly accurate, Mr.?
That is entirely accurate, Your Honor.
Okay. I don't think we need to go too far down this road, Mr. Ader, but Mr. Merritt, I generally agree that if they want to give me evidence about Mr. Edelkind's behavior in an effort to demonstrate that the relative balance of equities that the court has to engage in for a TRO assessment are then I think it is relevant. But again, we don't need to get into all the salacious details. I just need to get a general flavor of the circumstances.
Understood, Your Honor. So I restate my question. Chris, has Mr. Edelkind ever spit at you?
He has.
All right. Was that in relation to the construction of a wall and a fence?
I guess it's with his frustration. That's my only guess. If I'm on that right side of the property, he spit at me and called me vile names.
Understood. What was the first instance of overt aggression, and when did it occur?
Um, it was it was right after the wall was built. I was put the fence there and I was walking along the right side with Mr. Jones, and he spit at me and called me a bitch.
Yeah, and that was in relation to the collapse of the wall and you're building a new wall, correct?
Correct.
Did he threaten to destroy the wall or the fences?
Yes, he actually hired a contractor who I spoke with, who told me he was paid to
I'm
tear
going to
down the wall.
object as this is hearsay.
I would tend to agree, Mr. Rader, if you want to move on.
Let me restate my question. Do you have reason to believe that he was going to destroy the wall? As in, did he ever tell you himself that he
Yes,
was going to do so? Right. And this contractor, they did tell you that they were, maybe let's leave out what Mr. Edelkind said to them, because as opposing counsel has noted, that's hearsay, right? We want to make sure that we're hearing statements directly from the horse's mouth. But this contractor, did he tell you he was hired to destroy the wall?
yes.
Okay.
Again, Your Honor, that's hearsay.
Okay. I think it's a matter of, I agree with you that the way the question is framed, it is a matter of hearsay, but I think that if you want to try and rephrase, or we can just move on.
Did you ever observe contractors on the property who stated they would destroy the wall?
Yes.
I'm sorry to beat a dead
Still
horse.
hearsay.
Yes.
Right. I mean, here's what I will say. I think that it appears to me that Ms. White observed contractors on the property that she believed were there at the direction of Mr. Edelkind. And that at some point she developed an understanding that perhaps they were there to take the wall down. And we'll move on.
Okay.
Correct.
Thank you, Your Honor. Did Mr. Edelkind or his wife, presumably on his behalf, ever initiate formal legal action regarding the retaining wall?
Yes.
What was the outcome of that case?
His lawyers dismissed it before we went to hearing or trial.
Okay. Has he taken any other legal action against you?
Yes, he has.
And what is that?
A claim that some construction debris blew onto his property and his wife slipped and fell on it.
All right. And what is the current posture of that action?
I'm not 100% sure. My liability insurance legal counsel is taking care of that.
Understood.
Where are those cases, out of curiosity?
One of them was dismissed unilaterally by the plaintiff. Another one is currently pending motion to dismiss.
Before whom?
I'm not entirely sure.
Okay.
Freeman Matheson Gary is handling that because the insurance company was named.
Sure. I was just curious if it was Fulton County Superior Court,
I believe
state
it's
court, or.
I believe it's Fulton Superior, but I'm not entirely sure, Your Honor.
Okay, thank you.
I think the first property case was in Fulton Superior. The other one might be in Fulton State, but I think they're all in Fulton.
Thank you. Well, I assume they'd be in Fulton, but whether they're in state or Superior matters. So thank you. Go ahead.
Despite these cases, did Mr. Edelkind continue his threat to tear down the wall?
He did.
Does he often stare at you or your workers?
Yes, he does.
Does he continue to do so?
Yes, he has.
During those interactions, do you believe that he was trying to intimidate you?
Yes, I do.
And why do you believe that?
At one point in time, I heard him, this is my opinion, tell the guy that was standing next to him that he was the master of intimidation.
All right. Does he ever yell at you during these confrontations?
Yes.
What
Usually
is,
just name calling.
yeah. What kind of names?
He uses bitch as a reference, but there's other profanity with that.
You'd say it's misogynistic or abusive language?
Correct.
Okay.
I'm just going to object to the continued use of leading questions.
Fair enough.
All right. Specifically, what kind? So, has Mr. Edelkind ever made any reports or done anything else to try to slow down the project?
Yes, he's repeatedly called the city of Atlanta about various items that were immediately dismissed, but they caused stop work orders and delays in the process.
How many times has that happened?
I believe 5 times. I had 3 stop work orders because of it that were dismissed once they clarify it. When the city of Atlanta receives a call, they have to investigate regardless, but at some point in time, they stopped investigating because it was harassment.
How did those calls affect you?
We got the stop work order. I have to pull all the men off the work. I have to pay them for a full day. They have to leave at whatever time the city of Atlanta comes. And then I have to go through the process of talking to the city, showing them the incorrect call, and get the stop work order lifted. So it causes maybe a week's delay. And carrying a loan and carrying the process is just a financial burden.
All right, and how did you respond in these situations? Like, was there anything you did that to try to limit the damage to yourself?
I mean, I have everything done according to the permit, so it's just a matter of getting quickly to the city of Atlanta, showing them the documents that proves that it is a false claim. It's just I do everything as quickly as possible to keep it rolling. Have not spoken to Mr. Edelkind about any of this. I just keep rolling with my project, trying to push it through.
Have you ever had to hire on-site security or anything like that when working in view of Mr. Edelkind?
Yes, when we work on the right side of the property, I've had 5 different days where I've had off-duty City of Atlanta police officers on site to limit the harassment of my workers.
All right. Uh, has on-duty law enforcement ever been forced to report to the job site as a result of the dispute over the wall?
Yes.
How many times have been called out?
4 times, I believe it was 3 times involving harassment. I thought it was the 4th time, actually, they were not there for me. They were there for a domestic violence call at his property.
Understood.
I'm going to object to that for lack of foundation.
Okay. I'll strike it. Go ahead.
All righty. Was it clear to responding officers what needed to be done?
Object to form. I mean, sorry,
Yeah, that's asking
Yeah.
you to speculate.
lack of
Okay.
foundation and calls for
Understood.
speculation.
Understood. Was it clear to officers who owned the wall in question when they arrived at the property?
Same objection, Your Honor.
I agree.
Did an officer ever tell you that they believe the wall was on Mr. Edelkind's property?
It calls for hearsay, Judge.
Let me back. I agree with you, Mr. Merritt, but let me back up and say this. I was under the impression that while there might be an easement, that there's not a dispute that wall is on Ms. White's company's property. Is that not accurate?
I do not think it is accurate.
Okay.
Miss White, have you ever heard Mr. Edelkind state that he owns that wall or that it's on his property?
Multiple times.
Do you believe sorry, I don't want to ask you to speculate, but could you tell us exactly what the outcome was of these police visits to the property?
They were not, the police could not say, they had my survey. They have the points that are pounded into the ground by the surveyors and by the city of Atlanta, but the police just said it's not their call. They can't make that assessment 100%, whose it was. We have supporting document. His surveyor was out, my surveyor was out. They both agreed where the property is. It's just not being comprehended properly, I guess, is the nice way to say it.
All right. So they said, so is it fair to say that it's not immediately clear to law enforcement reporting to the property that the wall is on your side of the property line?
Objection calls for speculation.
That one I don't agree with. That one's overruled. Go ahead.
Thank you, Your Honor.
Correct. There's the pins in the ground from the surveyors are there, but the police were not willing to, I guess, stand by that. But the surveyor points are there in his driveway, showing that that's my 3 feet of property. But it just was difficult to withhold, I guess. I don't know, from their police position, they didn't want to get involved in a civil situation, I think.
Understood. All right, so where do we stand today?
The home is complete. It is for sale. We're just having, appointment only showings multiple times a week, people coming in through the property to view it. And we're just waiting for the sale to be completed.
Has Mr. Edelkind ever temporarily ceased his threats or harassment only to resume the behavior later unexpectedly?
Throughout the process, there were lulls. There was some
Mhm.
intense situations, and then there was lulls, and we didn't hear much from him. And then he would strike and call the city or call the police or do something else. So it was a very roller coaster ride up and down.
All right. Do you believe that absent a court order, Mr. Edelkind will cease interfering or attempting to intimidate you, your agents, or prospective buyers?
I think he will continue.
Do you think that there is a possibility that at some point in time, the wall could just simply be destroyed?
I believe so. And that's was my biggest fear the entire, I didn't know from night to night if something was going to be torn down by the time I got there.
What effect would damaging the wall in front of prospective buyers have on your ability to complete this project or sell the home?
In
Calls
my
for
experience,
speculation.
I'm sorry, Mr. Merritt.
I said object just because it calls for speculation.
You can rephrase.
Based on your considerable experience over the past 2 decades as a home builder in Atlanta, would it be possible to sell a home of this value with damage to a retaining wall located on the property?
no, it would not. There would have to be a repair of the wall to bring it back to its pristine condition that it is now, and then perhaps an explanation as to how it got damaged, which would not bode well for the sale of the home.
Yep. And absent a court order, do you, again, you believe Mr. Edelkind is likely to, at a later date, resume his threats of destruction or harassment?
I do.
All right. That'll conclude our direct.
Thank you. Mr. Merritt, questions for this witness?
Sure, just a couple. Is why when you were asked by your attorney whether or not Mr. Edelkind has brought any other legal action against you, you mentioned 2 lawsuits. Do you recall that?
Yes.
Okay, and one of those was a personal injury lawsuit, correct?
I guess that's what it's called. It's a civil suit, so whatever that means.
Which,
Yeah,
by
I
the
think
way, is pending in Fulton State Court. I checked.
Okay, I thought it was, but I wasn't sure. But I think you had mentioned that the other lawsuit, the second lawsuit, related to like a slip and fall that Miss Edelkind claims to have suffered, or something like that. Do you recall that?
Correct.
Okay. But my client, Mr. Edelkind, is not a party to that lawsuit at all. Fair?
Objection.
If she knows, she can answer.
I don't, honestly, I'd have to look and see who's actually on my file in the paperwork. I probably have it here somewhere. I'm not exactly sure what the plaintiff's actual name. If it's both of them on the suit, I could probably find it if you give me a minute.
Well, no, I'm only asking you because when your attorney asked you if my client, Mr. Edelkind, had brought any other legal actions against you, that's one of the lawsuits you mentioned. So I
Yeah,
assume.
I mean, I believe his name's on the paperwork. Give me 1 second. I just have to find the paperwork. It's gonna take me a minute. I don't, oh wait, here's.
I can search for this as well, Your Honor. It's a matter of public record.
Well, it's also a matter of my docket. and I can
Actually,
tell you
yes, it
that
is. It does say, I have it right
Yeah.
here, Your Honor. It's right
In my
here.
docket, it says Patricia and Steven
Yes.
versus ATL Custom Spec.
Correct.
Okay. You mentioned earlier that the retaining wall, and by the way, when we refer to retaining wall, are we, I just want to make sure we're on the same page. When I say that, I'm referring to the stone wall that is on the left side of Mr. Edelkind and Mrs. Edelkind's driveway. Are we talking about the same thing?
Yeah, it's technically not a retaining wall. It's a border wall, I guess you would say. It's not retaining dirt.
Okay.
And it's on my property. Yes, it's on my 3 feet of property.
Okay. You had mentioned that that had collapsed due to rain or water or something like that?
No, I just think it was unstable to begin with, but I excavated several feet from that, and then we had 3 feet of rain, and I think it just lodged the soils there, which then dislodged the
Okay.
rubble wall.
So probably the excavation work that you guys were doing mixed with some weather conditions and maybe some other factors all combined. Is that kind of what you're saying?
It's hard to say. You know, I don't know because it was just I don't know. I didn't assess the wall because we were far enough away per the plans. We excavated as per the plans. So it's hard to say what that combination was.
Okay. Now, you mentioned earlier when your attorney asked you about the easement that you were aware that there was an easement in place. Do you recall that?
Yes,
Have you ever actually looked at that easement?
yes.
Okay. What is your understanding of what rights were granted by that easement?
That they were allowed to, well, it was required that they could put a division wall, this, whatever this wall we want to call it, and use that for the expansion of his driveway. And in that right to be able to use my property, they did need to maintain that wall.
Okay. So, and when you say wall, again, wall, we're talking about that same retaining wall that goes on the left side of Mr. and Mrs. Edelkind's driveway.
Yeah,
Correct.
it was less than 2 feet tall.
Okay, so Mrs. Edelkind, as the title holder of the adjacent property, was given an easement by your predecessor in title to have the right to construct and maintain that retaining wall on the left side of their driveway, correct?
Yes, that's my understanding.
Okay. So if that is do you have any reason to believe that that easement is invalid or not currently enforceable?
Objection calls for a legal conclusion.
Overruled. She can answer if she has an understanding.
I mean, I guess so. I mean, I don't really understand the question.
Okay. If that easement gives Mrs. Edelkind the right to construct and maintain that retaining wall that collapsed and you guys rebuilt a new wall in its place, why wouldn't Mrs. Edelkind have the right now to make changes to that wall at her expense?
Because they didn't maintain their wall. I have some of that section of wall is still there and it is dilapidated and aged. There was no maintenance done on it. So in my opinion, I'm not legal, that would be a violation of the easement.
Okay. Is that somewhere in the easement? Like, are you
Part of it, the wording is that they have to maintain that, and they
okay?
did not
All right. And why do you say that they didn't?
because it was falling apart. The rocks were falling out of the wall. There's sections that are still there that they're not stable.
Okay.
So that probably led to why it fell into where I was working.
Did you ever perform an inspection of that wall prior to the excavation work that you and your company were doing?
No,
Okay, so, and you just mentioned earlier, you can't really say for sure why that wall collapsed because you had excavated on the other side of it. Plus, there had been rain and there was a lot of other factors, so you can't really say for sure why it collapsed. Fair?
fair.
Okay, and you never inspected it before you guys excavated most of the dirt on your side of the boundary line. You just
I mean,
testified to that.
we looked at it. We looked at it. And
Right, but just
I mean, there wasn't like a formal inspection. We did realize there is no footing and there was no rebar, but it was also not maintaining, it wasn't retaining any dirt, right? There wasn't anything for it to retain. It was basically a border between driveway and dirt.
okay. So in what ways did Mr. and Mrs. Edelkind fail to properly maintain that wall?
Because there was parts of it that were already missing, like rocks of it already missing. Like it wasn't maintained in terms of, and then they also built a fence on top of the wall, which was not part of the easement. That was not granted in the easement, the allowance of putting a fence on my property. That was actually not part of the easement. And that was also dilapidated and falling apart.
And
And I do have
again,
pictures of those.
okay. All right, that's all. That's all I had.
Thank you, Mr. Merritt. Any follow-up for this witness, Mr. Ader?
Just a few questions. Chris, you mentioned that you have extensive experience. Do you have any qualifications as, say, like a structural engineer or anything like that?
I mean,
I'm just going to object because this falls outside the scope of a redirect. It's beyond what I was asking about in cross.
It's not, though. She testified that she provided.
It's okay. You can stop selling. I'm already buying. But yeah, I'm going to overrule your objection, Mr. Merritt. Go ahead, Mr. Ader.
So it's safe to say that in your experience, you have considerable knowledge of retaining walls and structures similar to that.
correct.
Yes, because I believe you testified that this wasn't technically a retaining wall, right?
Correct.
Right. Do you have any qualifications that would make that inspection, and again, you looking at it, uh, that it would help you to understand what you're looking at there?
Yes, I do.
And what are those qualifications?
I have a bachelor in civil engineering, specializing in structural engineering, and master's studies in
Right.
engineering as well.
So based off of your considerable experience in that area, do you believe that wall was initially constructed properly?
I do not,
And why is that?
because there was no footing, there was no foundation for the wall. It was just rock set on the ground with concrete between it. There wasn't.
So forgive me, I'm an attorney. I don't understand as much about building, of course, as somebody like you.
Well, hang on. Let me interrupt you and tell you this. I literally spent an entire week in a bench trial where lawyers were explaining to me what a retaining wall was versus a border wall. And I had to explain to them that I have one of those in my backyard. So I'm pretty sure I know what a retaining wall is.
Gotcha.
So I'm going to save you that part of the trouble of I do have a general understanding, assuming that no one has an objection to that, but I do have a general understanding of what makes a wall a retaining wall in terms of her reference to it retaining other things behind it and having the general construction rules of it versus a decorative or border type wall. So we can move on from there.
Mhm. All right, so based on, and how long ago was the wall constructed? Do you know?
The easement is from uh, late 80s, I believe. I think it's 40 years.
Yep. And in your experience, would a wall need maintenance work over the course of 4 decades?
It does, of course.
Okay. Do you believe that maintenance work was done on that wall for any reason?
I do not.
Okay. I think that concludes our questioning for this witness, Your Honor.
Okay, Mr. Merritt, anything else on those questions?
No, Judge.
Okay, thank you, Ms. White. You're excused as a witness. Mr. Ader, do you want to call the other witness?
Yes, I'd like to call Mr. Jones now.
Okay, Mr. Freehoff, can you please let was it Mr. Jones back into the room? Off the record, Madam Court Reporter. Simran, will you check and see if Mr. Freehoff is in his office or if he's gone into the courtroom? Thank you.
Oh,
Oh, there he is. I found him. And it's still off the record, just so you know, the young woman who just walked in is a rising second-year law student at Georgia, or is a second-year law student. I'm sorry, at Georgia State, Simran Carr, and she is interning with me this semester. So continue to demonstrate the good lawyering that we like to see. So in any event, Madam Court Reporter, we can go back on the record. Mr. Jones, if you can unmute, please, and raise your right hand. Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, sir. If you'll lower your hand. Go ahead, sir.
all righty. Would you please state your full name for the record?
Jeremy Adam Mullet Jones.
All right. What is your profession, Mr. Jones?
I own an interior design firm in Atlanta, Georgia.
All righty. What is your connection to the project at 843 Yorkshire?
I was engaged by the client in 2023 initially to begin the design work on the home to take it to fruition, to complete the project.
All right. Have you ever met the defendant?
No,
You've never interacted with Mr. Edelkind?
I've interacted with him. I've never spoken to him personally. He
Got
has spoken in my direction.
When was the first time that he spoke in your direction?
I believe, because I went through some photo records that we have at the office, I believe it was Halloween, October 31st of 2024. I was on a job site review. We had just begun framing the home shortly before then, and we were walking the job site from the back of the property to the front of the property along the side of the home facing the driveway of the neighbor. And he came up to the fence and said something to Chris. and she held up her hand and said, "You'll speak to my attorney." And he hocked a loogie at her and then turned as I was approaching him. He hocked one at me.
So you were walking from the back towards the front yard.
Yes.
Um, this would be over the retaining wall.
I, bel I believe at that point the retaining wall had, I don't think it had collapsed then. So no, it had already collapsed. I think she had already fixed it or something. So we were just walking in the dirt. There was a small wall coming up and then a fence on top of it, if memory serves.
Yeah. So you were standing, it sounds like on uh, the plaintiff's side of the property line. The defendant was standing in where? Where was the defendant located?
On their side of the fence.
Mhm. And this would be the fence that was on top of the retaining wall.
Yes.
Um, were there any other interactions that day? Did he follow you or did he stay near the wall?
Um, he stayed near there and was raising his voice and saying something to us that I couldn't really make out while we were surveying what we had moved to the front of the house to examine, which to my memory was there was a discussion about adding a window in the basement, the ground floor bathroom, which was not originally a part of the plan. And so we were looking at considering doing that, and we decided not to, um, which was facing his property.
Okay. Have you ever been present at the property when police were called out?
Yes. I believe it was this. Chris had mentioned that there were several instances where the police had been called to the property. I believe I was there for probably the last one, I hope, which was uh, I believe it was November 17th of 2025. Again, according to my photo records, we maintain thousands of photos of job site progress.
Yep. So did you witness a police officer on the property that day?
They were not, at that moment, they were not on the 843 Yorkshire property. They were standing at the bottom of the driveway
Okay.
and had been called by um, Mr. Edelkind, Edelkind.
Mhm.
Um, and that was basically my experience.
Right. So do you think it was clear to the police at that point in time uh, that the wall was located on our client's property?
Can you repeat the question?
Do you believe that it was clear to the police that this wall was located on our client's property?
Objection calls for speculation.
Agree.
Um,
I think, Mr. Jones, what would be helpful is if you, as whatever you observed that day, personally observed, did you develop an understanding of whether the police knew where that wall, who the wall belonged to, or whose property the wall was on?
I did not speak to the police. I only was told that they were there to try to prevent people, prevent subcontractors from walking over to repair something.
I see. Okay.
And they were being, it was something that was agreed upon, and Chris was supposed to be walking through the property with me, and her team was prevented from going onto his property per their previous agreement in order to repair something that she had stated that she would repair.
Okay.
Um,
But the
so
police were preventing that from happening.
right. So that it's your understanding, Mr. Jones, that that prevented the job from progressing that day.
Yes.
Okay. Um, and so how long have you been working as an interior designer?
25, 25 years.
25 years. Um, have you ever witnessed anything like this before?
No, I have not. Um, not not anything to this degree. There have been, with a few contractors, there have been some instances of of, dispute at some point between the contractor and the neighbor or something, but never anything to this degree, no.
Okay. I think that'll close our direct line of questioning.
Thank you. Mr. Merritt, questions for this witness?
Thanks, Judge. Mr. Jones, you mentioned just a couple seconds ago that Miss White had told you that she wanted to go over to repair something that you guys had damaged or became damaged on Mr. and Mrs. Edelkind's property, but she was prevented from going over there by the police. Is that correct?
That's not exactly the phrasing that I used. What I stated was that according to her, they had come to an agreement. Her and Mr. Edelkind had come to an agreement for her to possibly patch something or maybe paint something. It was something small on his side, and she had to have access to that. He had called the police and had prevented those people from going over to perform the work necessary. That's all I'm aware of.
Okay. So you don't know what specific
No.
work was. Okay.
I don't recall.
Gotcha. That's all I had.
Okay. Anything else, Mr. Rader?
No, I think that'll do it for us, Your Honor.
Okay, Mr.
Thank-
Jones? Thank you
can
for
you-
being here. And
say-
unless you need him for any reason, he's free to be excused.
That is exactly what I was going to ask, Your Honor. I know Mr. Jones has a busy schedule.
Thank you,
Thank you
sir.
all.
Have a good day.
Thank you.
By the way, Your Honor, were those witnesses sworn in?
They were. I swore them in myself.
Okay. I don't know why I'm like losing it today. I apologize.
Don't worry. I have those moments myself. Someone will be an hour into their testimony and I'll be like, wait, did we swear them in?
Yes, I've done that at depositions too. Where
Yes.
I've got 2 hours in and I was like, oh my gosh.
Mr.
Okay,
Ader, do
sorry.
you have any other witnesses, sir?
No, Your Honor.
Okay. Mr. Merritt?
Yes, Your Honor, I'd like to call Stephen Edelkind.
Okay. Mr. Edelkind, can you please, thank you, unmute, and will you please raise your right hand? Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You may lower your hand. Go ahead, Mr. Merritt.
Mr. Edelkind, please state your full legal name for the record.
Stephen Edelkind.
Okay. And what is your wife's name?
Patricia Edelkind.
Okay. And what is the address of the property that your wife owns?
837 Yorkshire Road, Atlanta, Georgia.
Okay. How long have you and your wife been married?
45 years.
Okay. How long have you and your wife lived at this property on Yorkshire?
My wife had lived in this house entirely before we got married and after we got married. Me, I have lived in our house in Florida and back here in the house.
And tell me a little bit about yourself. Did you go to college anywhere?
Yes, I did.
Where did you go?
Orange County Community College.
Okay. Have you ever served in the military?
Objection
Oh,
relevance.
yes, I did.
Okay.
Well, I heard a little bit about Ms. White's background. I'm happy to hear a little bit about Mr. Edelkind's.
And what branch did you serve in?
Navy,
Okay. Were you honorably or dishonorably discharged?
honorably,
Have you ever been arrested for any reason?
never,
Okay. Have you ever been charged with domestic violence or domestic assault or anything like that?
never,
Okay. Have you ever had a restraining order taken out against you for your behavior towards any other person?
never,
Okay. Have you ever harassed or called any Miss White or any of her workers racial slurs, misogynist slurs, curse words or anything like that?
no,
Okay. Have you ever intentionally spit at Miss White, Mr. Jones, or any of the other workers or guests on the adjacent property?
never,
Okay. Have you ever threatened to do them any physical harm at any point in time?
no,
Okay. And are you familiar with the easement that has been discussed today?
yes,
Okay. And am I correct in understanding there was testimony earlier that that easement grants your wife the right to construct and maintain, we've been calling it a retaining wall, but a wall on the left side of you and your wife's driveway?
Yes, I'm very familiar with the retaining wall.
Okay. And I believe that Ms. White testified that she believed that that wall had been there for about 40 years. Is that your understanding?
No,
Okay. When was that retaining wall constructed?
probably at least 10 to 15 years after my wife and I got married,
Okay.
because
I'm sorry.
the wall that was existing was collapsing. And I spoke with Mrs. Scherer, who owned the property, and I told her we need to fix that. And she said, let me get my attorney. She got an attorney, and he gave me what he needed, and we went along with what the attorney said, and it was done.
So the wall that was originally there that recently collapsed, at least in part, had been there for, I guess, around 30 to 35 years or so, at least.
I don't know.
Okay. I think you said that you and your wife had been married for 45 years.
That is correct.
All right. And that this wall was constructed, the wall that's there now was originally constructed 10 to 15 years after you and your wife got married.
No, there was a wall there before, and the wall that was there before was collapsing, and we had
Right.
to.
Yeah, no, I understand. I'm talking about the wall, the current wall.
The current wall was built after they removed all the remnant of the other wall, and we built it. And Mrs. Scherer's attorney approved it, and it was not a problem.
Okay. So, and that wall had been there around 30 or 35 years.
Correct.
Okay. The current wall. All right.
Yes.
And on top of, or right above that wall, did you and your wife ever construct a wrought iron fence?
The entire length of the wall.
All right. And was that fence paid for by you and your wife?
Yes.
All right. And what about the current retaining wall that's there now? Was that constructed at you and your wife's sole expense?
Yes.
Okay. Now, there was some testimony that the rain or the weather or something like that may have caused this retaining wall, for lack of a better word, to, or at least partially cause that wall to collapse. Do you believe that the weather or the rain had anything to do with it?
Not at all.
Okay. Now, in the last 35 or so years that this retaining wall has been standing, have you and your wife ever had any issues with it?
Not at all.
Okay. Has it ever collapsed before and had to be fixed?
No.
Okay. And what was the appearance like of the retaining wall? What was it made of? Describe it.
Granite.
Okay.
It's a granite retaining wall the entire length of the property.
Okay. Now, after the adjacent property was excavated and the retaining wall, I guess, collapsed on itself, you heard Ms. White say that her and her company reconstructed that wall. Do you recall that?
No.
Okay. So let me just ask you this. Did her and her company build something in place of the part of the retaining wall that collapsed?
What was the question again?
Sure. Did Miss White and her company, when the granite retaining wall collapsed, when it partially collapsed, did Miss White and her company reconstruct a different wall in its place?
It did not collapse at all. Mrs. White tore it down and she undermined the driveway.
I understood, and I appreciate that. But right now, I just want to know, like, when that wall fell over, the granite wall that had been there for 35 years, did Miss White and her company build a new wall in its place?
It did, number one, it did not fall over. It was solid, not a problem. And after Miss White tore it down, she built a knee wall out of cement,
Okay, out of cement?
out of cement.
Okay, so it wasn't the wall that she built was not made of the same materials as the rest of the wall. Is that fair to say?
No, not at all.
So yes, that is fair to say then, correct?
I'm sorry?
The part of the wall that Miss White and her company rebuilt is not made of the same materials as the original wall, correct?
Yeah, that's correct.
Okay. And it doesn't look the same, correct?
Definitely not.
Okay. And do you and your wife desire to reconstruct the wall to make it uniform and look the same way that it used to look before it was torn down?
Yes,
Okay. And that would be the right that your wife has under this easement, correct?
what is the question?
That would be the right that your wife has under the easement that we've discussed, correct? To construct that retaining wall.
Under what easement?
Yeah, you're aware that we've been discussing an easement today?
My wife we can reconstruct the wall because it is on my wife's property, and we don't have to get permission from the contractor or anybody else. It's my wife's property, and she put up this cement wall without our permission, and that's where it is right now.
Okay. Your Honor, may I share my screen?
Sure.
Your Honor, I'm going to object to the introduction of evidence. No exhibits were shared with us prior to the hearing.
Well, assuming from what I'm looking at that all Mr. Merritt is going to do is show photographs of what the property looks like, I think that's reasonable and not too far outside of, given that this is a TRO hearing. Not for nothing, but it would also help me put in context the testimony I'm being given about what this wall is or what it used to be. So your
Right,
objection,
so-
your objection's overruled, just to be clear. Go ahead.
Mr. Edelkind, you see the photo that I've shared?
See,
Can you see the
repeat
photo?
question?
Can you see the photo that I've shared on the screen?
Yes,
All right. And are those the granite stones that you're talking about that make up your driveway and the walls on either side of your driveway?
the granite stones that make up the driveway, yes.
Now, I'm just going to show you an image that I obtained from Google Street View. Do you recognize this image?
Do I recognize what?
Do you recognize this image? This is from Google Maps.
I recognize the driveway, yes.
All right. Is that you and you're in your wife's driveway?
That's my wife's driveway.
Okay. So this would be how the house you see to the left of this image, that's the one that was torn down and the new house was constructed on Miss White's property, correct?
Repeat the question.
Yeah. Do you see this house here on the left side of this image?
Yes,
All right. So that's the house that was torn down where Miss White and her company rebuilt the new house next to yours, correct?
that looks like it was Mrs. Scherer's house.
Okay. So this driveway your driveway right here, you and your wife's driveway, that's how your driveway looked before construction began next door. Is that fair?
That is correct.
Okay. Now, you can see that that's the wrought iron fence we've been talking about that you and your wife constructed, correct? That's kind of leaning over to the left.
Yes,
All right. And you can see where this retaining wall, for lack of a better word, kind of ends and the rest of it is now missing. You see that?
yes.
Okay. What happened to this wrought iron fence that you and your wife constructed at your expense?
It was torn down by the contractor, and she had it put on a truck, and she stole the fence and took it off the property without our permission.
Okay. So again, this is your driveway. This is near the top of your driveway?
It's leading up to the top of the driveway, yes.
Right, okay. Now, in this photo, you can see the new cement, I think you called it a knee wall.
It's a knee wall, yeah.
All right, so this is the cement wall that Miss White and her company built when the historical granite wall was knocked down or collapsed, correct?
She built that after she undermined the driveway and took out the crush run that was there, and she hand shoveled her crush run into it. And
Okay.
then she built that retaining wall out of cement to more or less hold her crush run in that was not put in properly.
Okay. All right, and then this is another photo. This is you can see another view here. This is the concrete or cement wall that Miss White and her company constructed where the old historic granite wall had been standing for 30 or 35 years prior, correct?
Yes.
Okay. All right, and then this, you can see now where the old existing granite wall ends and the new cement or concrete wall that Miss White constructed begins, correct?
Correct.
So we're looking at the left side of you and your wife's driveway, correct?
Yes.
All right, so you and your wife, is this what you were talking about earlier when I asked you, would you and your wife like to reconstruct that wall to match the existing historical wall?
We would like to remove that knee wall that she built. We're going to have to dig up the driveway itself because it's collapsing, and and when she put in the crush run that she did, she had it hand shoveled into there rather than put it in correctly, and she did not put in cement to hold it in place. So it's sitting there, and the driveway is collapsing presently.
Okay, but again,
Mr. Merritt, sorry, how does Mr. Edelkind profess that he knows that? Is there some expert or someone who's advised him of that?
I think he has had a contractor come out and examine it. We don't have that person here today, and I wasn't going to get into that because it's
Well,
hearsay.
and that's actually part of why I asked the question is that the larger issue of the whose rights, at least I think I understand that the larger issue of the where the wall is and who has rights to it and who does not is the larger issue for this litigation, and that I'm only dealing today with the shorter term issue of Mr. Edelkind's interaction with that wall and with the people on the other side of the property. Are we in agreement on that for today, Mr. Merritt?
Yes, Your Honor. I mean, actually, it's even more restrictive than that. I think the only issue you're dealing with today is whether or not Mr. Edelkind should be enjoined from assisting his wife in reconstructing this wall. So, all right, I'm going to stop sharing. Mr. Edelkind, have you ever personally walked outside of this retaining wall area? Have you ever personally walked over to the property next to yours where Miss White and her company have been building this house?
Yes, I did.
Okay. Have you done anything to interfere with Miss White or her company's workers from building that house?
No, I did not.
Okay. Do you have any desire going forward or any plans to trespass onto the adjacent property for any reason?
No, not at all.
Okay. And whatever work is necessary to rebuild this retaining wall or tear down the knee wall and rebuild the retaining wall or do work to your driveway, all of that work would be done either entirely on you and your wife's property or done pursuant to your wife's easement rights. Is that fair?
Repeat the question, please.
Sure. What is it your understanding that whatever work would need to be done to fix your driveway and recreate this retaining wall, reconstruct this retaining wall where the concrete wall is now standing? All of the work that would need to be done for that would either take place entirely on your wife's property or would be done pursuant to her easement rights. Is that correct?
No, that's not all the work. The driveway is collapsing and there's big cracks in the driveway.
No, I understand that, but that driveway's on your wife's property, correct?
And that is correct, but it's collapsing because the
Well,
crush
I don't want
run, the crush run that the contractor hand
Okay.
shoveled and she did not put it on correctly, caused the driveway to collapse.
I understand. I don't want to get into what needs to be done. I don't care about what needs to be done. I care about where it needs to be done. So the work that needs to be done, I understand that work needs to be done, but all of that work would either be done entirely on your wife's property, or to the extent that you have to rebuild this knee wall, tear that knee wall down and rebuild your original wall, all of that work would either be on your property, your wife's property, or pursuant to your wife's easement rights. Correct?
Yes.
Okay. Now I have no further questions at this time.
Thank you, Mr. Ader.
Sure. Mr. Edelkind, it was your testimony today that the wall was constructed around the time that you signed the easement with the Schurz, correct?
Repeat your question, please.
It was your testimony earlier today that the wall was constructed around the time that you signed a new easement with the Schurz, your former next door neighbors?
Give me the time frame. You're saying a day, a week, a month, a year? What time
Sure.
frame are we talking about?
When do you believe that the retaining wall, the initial crushed granite wall, was constructed?
I didn't get the question.
When do you believe that the wall that was on your property was constructed originally?
I need clarification on the question.
What
Okay.
part, Mr. Edelkind? Here's what I think I understand, that this dispute is about a wall that was there that came down. I understand you allege that Ms. White took it down, but that came down in July of 2024. And I think I understand Mr. Ader's question to be the wall that was there until July of 2024. When was it put there?
The wall that was there? I have no idea when it was put there.
Did you put it there? You and your wife?
No, I did not.
Did you hire contractors to put it there?
No,
Okay.
it was an existing wall.
Okay.
So why sign an easement with the Schurz to build a wall if there was already a wall there?
What is the question?
Why would you sign an easement with your next door neighbors to build a wall if there was already a wall there?
Now, I'm not trying to object the question. I just would object to facts, not in evidence, just because he never signed any easement. I'm fine with the question other than that.
The question was asked before and I responded to it. The wall that was there when Mrs. Scherer was alive was collapsing and she got an attorney and we agreed to rebuild it at our cost and the attorney approved it. So
When?
that's why it was
When
redone.
was that, Mr. Edelkind?
Your Honor, if I might share my screen, I think I can shed some light on that because we do have a copy
You
of this.
can, but I'd still like for Mr. Edelkind to tell me when his understanding is of when that happened.
I don't have the dates in front of me.
Can you estimate reasonably? I mean, was it in the 1980s? Was it in the 1990s? Was it? If you can't, that's fair. I just wanted to give you an opportunity to estimate.
I don't, I don't really recall. It could be in the late 70s,
Okay.
early 80s, so I don't have that information in front of me. I could find the prior attorney's documents and my agreeing to rebuild the wall at our cost.
Okay.
So
Well,
I could,
Mr. Ader is gonna show us, I think, the easement maybe that was executed, and so maybe that will help us. Go ahead,
That was what
Mr.
I
Ader.
was, that was what I was hoping, Your Honor. So I'm going to represent to you that this is the easement from page 397 of book 10676. Do you recognize these signatures and the names? Barbara Scher, Anne Elizabeth Scher, and Patricia S. Edelkind?
I recognize my wife's name, and I need to see more of what this document is.
So this is page 3 of this easement.
Okay, I see Mrs. Scherer's name
Mhm,
and Barbara Scherer's, Barbara McAfee.
mhm.
Yes, I recognize them.
And who is Barbara McAfee?
Barbara McAfee was the daughter of Mrs. Scherer, and I think it was with her that the house was sold to the contractor. I was not privy to that.
Okay. Um, can you see this date right here? The one that's directly beneath the signatures of the witnesses and the grantors?
I
Would it
see
help?
these dates. Yes, 1987
All
was
right.
notarized.
So does that refresh your recollection that that may have been when the wall was built?
Repeat the question.
Does that refresh your recollection of when the wall may have been built?
It's possible.
Okay. So I think that establishes what we needed there. Since then, what maintenance efforts have been undertaken to keep that wall in good repair?
What is the question, please?
Since the wall was constructed in 1987, what maintenance efforts were undertaken in order to maintain that wall?
That it was reconstructed. What maintenance? Actually, there was no necessary maintenance effort that was necessary. The only thing that we did was put up the wrought iron fence on the entire granite wall going all the way up the driveway.
All right. You also testified earlier that the construction wasn't done properly. Do you have any experience in construction?
I do not have a license in construction. I am not a contractor, no.
All right. So you have no formal education in construction?
What is the question?
Do you have any formal education in construction?
Formal, no.
Okay. So what leads you to believe that the work was not done properly?
What are you referring to?
You testified earlier today that the driveway was not properly backfilled. What leads you to believe that the driveway was not properly backfilled?
Because I saw the people that the contractor hired hand shoveling crush run underneath the destroyed uh, driveway. In fact, she dug out the driveway underneath the driveway. And then when I brought it up to her, I said, it's going to collapse. She had her workers hand shovel, well, I don't know what grade of crush run, hand shovel it. And then she closed it up with the cement knee wall. And that was not the proper way to do it, according to my contractors.
So your contractors told you that that was not the proper way to do it.
Exactly.
And who are your contractors?
I don't have that information in front of me.
How did you locate these contractors?
I spoke to people that I knew, and they said in the insurance business, and they said, these are good contractors, get in touch with them. They came out, they gave their estimate as to what had to be done. And they said, definitely, there's different grades of crush run that needs to be put in. And it had to be the ground had to be pounded in first, which this contractor did not do. And then it had to be cemented in, which this contractor did not do.
Well, was your testimony earlier that it was shoveled in and then she cemented behind it? Wouldn't that be cementing it in?
What is your question?
You testified earlier that they shoveled in and then they cemented behind it. Wouldn't that be cementing it in?
That would be cementing in a bad product to cover it up.
So again, what qualifications do we have, or why should we believe some anonymous contractor who you can't identify over Miss White, who is here today to testify and has qualifications that everything was done properly?
I do not, as I testified before, I do not have any experience in doing this. I had to rely on the contractors that I hired to come over and evaluate the situation.
Have you provided anything involving that to counsel or shown it to Miss White?
No, I was not asked to do that.
Okay. So essentially what you're asking is that we should take your word for this, that you spoke with some anonymous contractor over Miss White, who's here sworn in to testify today.
Objection, argumentative, and asked and answered.
Agreed.
All right.
You're going to have to repeat your question, please.
That's all
It's
right.
o- It's
It's
okay.
all
He's
right.
going to move on, Mr. Edelkind.
Mhm. I'd like to show another picture of the job site, if that's all right. Mr. Edelkind, do you recognize this photo?
I recognize that, yes.
All right, so what am I looking at here?
You're looking at from the contractor's property, showing the wrought iron fence that we had built and my wife's house, and a plywood board that I put up because the contractor was photographing everyone going in and out the side door there. She was invading our privacy. So I had to put up that plywood to block.
On what basis do you believe that she was invading your privacy?
Because the camera was aimed right at the side door, and anybody coming into my house, my wife's house, had to go through that side door, and the contractor had her camera there.
So it's your testimony that that was put up to block footage from our client security cameras?
Please repeat your question.
So it was put up to block the field of view of our client security cameras?
To block her camera, yes.
Okay. Mr. Edelkind, it's your testimony that you've never spit at Miss White. Why do you think it is that she and Mr. Jones would testify that you had?
Objection. Calls
Because
for
she
speculation.
lies.
Oh, overruled.
I'm sorry, Mr. Edelkind, what was your answer?
I heard him. You can move on.
No, I'm sorry, Judge, I literally couldn't.
He said because she lies.
Oh, okay. And on what basis do you suggest that?
I have never spit at anybody in my life. I have never spit at any woman. I have never cursed at any woman. And she's trying to paint me as a abuser and all this, and she's totally wrong. Just because she had problems with her ex-husband doesn't mean that all men are like that.
Okay. Moving forward, it's your testimony then that you've never have, I don't know, called Miss White a curse word. You've never called her a bitch.
Never.
You've never, in your testimony, that you've never flipped her off or thrown to the bird or anything like that.
What is the question?
Have you ever made an obscene gesture at Miss White?
Never.
Now, have you ever referred to any of the workers on her property using racial slurs?
No.
All right. I think that concludes our redirect, Your Honor. Or
Thank
sorry,
you.
our cross.
Mr. Merritt, any follow-up with your witness?
I have no further questions and I have no other witnesses, but I would, if the court would indulge us, I would like to be able to offer a final closing argument.
Okay. Mr. Edelkind, thank you for your testimony. You can mute your Zoom, sir. Thank you. Okay. I would like to hear some brief argument from the parties. What I would like for you to focus on is that, what you have asked for is, and what you are opposing, respectively, is some sort of temporary restraining order that would govern Mr. Edelkind's allowable behavior and actions relative to the neighboring property. And my question when I'm asked to enter injunctive relief is always, tell me what relief you want and help me understand how that relief it satisfies the elements for injunctive relief, right? And for example, Mr. Ader, to give you a guide, I mean, one of the things I've heard is, while I have heard Mr. Edelkind say that his wife might choose to do something with the wall, I've also, I think I understand that wall's been there for going on 2 years at this point, and no one has messed with it. And so that maybe goes to the merits of whether there is one of the factors of injunctive relief. And if you can sort of take it from there and tell me what relief it is you want specifically, like if you want me to enter an order, what is it going to say that Mr. Edelkind can or cannot do? And tell me how that is necessary to avoid imminent harm, etc.
Yes, Your Honor. Throughout the proceeding of this case and throughout the construction of this project, so for the last year and a half, Mr. Edelkind has engaged, despite his testimony to the opposite, which will be addressed after this hearing, in a pattern of behavior that includes spitting, cursing, misogynistic and offensive profane language, shouting across the property, and repeated threats to destroy our client's property. They've concealed witnesses. I believe that their contractor would have been able to testify today that he was hired to destroy the wall, despite saying the opposite. The only thing that is preventing Mr. Edelkind from doing this during the pendency of just generally his ire and dislike and clear personal animus against our client is the fact that there are legal proceedings that are ongoing. If the court fails to enter an order, I believe that Mr. Edelkind will immediately start with destroying the wall and seeking to interfere with the sale of our client's property. There is just no chance that our client can sell the property if someone is screaming, cussing, spitting, or destroying retaining walls that are adjacent to it. So what we would ask the court to do is to enter a brief injunction to allow our client time in order to sell the property without this ongoing dispute interfering with their ability to do so.
Am I correct, Mr. Ader, that the larger question of the easement and who has rights to do anything with that wall is still at issue in this case?
I don't think it was going into the day. There were discussions multiple times between myself and Ms. Regas, who's sitting there with Mr. Edelkind, establishing where the property line is. Both parties have conducted surveys that have confirmed that the wall is on our client's side of the property, and yet Mr. Edelkind testified today that it is on his wife's property. So I do believe that there is some ongoing dispute as to who owns that wall and who owns the underlying property. We thought we had that ironed out going into the day, but the testimony of the parties is clearly contradictory to that.
Yeah, let me clarify my question. My question is in terms of the relief that is being sought and the work that the court anticipates needing to do, because oftentimes when someone's action is, I need an injunction and the court enters one, that's the end of the case functionally. But it doesn't sound like it is here if the easement is in fact part of the pleadings, if there is a request in the legal pleadings, either from your client or by way of response, for the court to resolve that issue? Is that in fact in front of the court?
I believe yes and no.
Okay.
The issue of the wall is in front of the court. The issue of harassment, which will be renewed as well with additional testimony, because I have some serious concerns about the veracity of testimony in court today, based off of my discussions with multiple witnesses, is I think there's a very good chance we will need to renew this and seek the court to have a second hearing as to the issue of harassment and profane language.
Okay. So I think I'm still not getting the answer to the question I'm looking for. If I give you a temporary injunction, right?
Mhm.
What, other than the possibility that you might need another injunction at some point, what further action is there for the court to take? It is part of the complaint to ask the court to legally pronounce the status of that wall and where it is on the property, et cetera.
Your Honor, I think we would need to plead in Patricia Edelkind in order for the court to have the authority to stay that, because
Okay.
Patricia
So
Edelkind
it's
is
not currently in front of me unless someone amends a pleading.
correct, Your Honor.
Okay, thank you. Anything else for now, sir?
No.
Okay, Mr. Merritt?
Yes, Your Honor. I'd like to begin with, I think, taking a shot at answering the question I believe you were asking. So there's three types of injunctive relief in the state: a TRO, temporary restraining order, an interlocutory injunction, and a permanent or perpetual injunction. What was actually pled is a TRO under 91165B. I actually don't think that's what we're here for today, because those generally are done without notice and by statute expire no later than 30 days after they're entered. It is also error at an interlocutory injunction hearing for a trial judge to enter permanent injunctive relief.
No intention of doing that, don't worry.
Right. I mean, I'm kind of just, this is a quick TED talk on
No,
injunctions, but
thank you, I appreciate it.
so I believe that really what we're here for today is on an interlocutory injunction under 91165A, which would basically serve the purpose of preserving the status quo until the lawsuit can be finally resolved, whatever
And
claims
that's
you
really
make.
my question is, what is it that resolves this lawsuit?
So
That's the part I don't understand.
sure. So as the lawsuit is currently situated with the present parties, I think the only thing that would remain after today, regardless of how Your Honor rules, is for the parties to perhaps take some discovery and then for there to be a final hearing for Your Honor to decide whether or not a permanent or perpetual injunction is warranted. For today, it's just the only issue is whether or not there should be a interlocutory injunction which restrains or enjoins Mr. Edelkind from doing anything to tear down the wrought iron fence or the retaining wall. That's what's on the face of the verified complaint. And I think the court is bound by the sworn allegations in the complaint, none of which under that count mention harassment, spitting, or anything else. They are strictly to preserve and protect what is claimed to be irreparable harm to property rights. Now, there are factors that Your Honor is obligated to consider when deciding whether or not this relief is appropriate. Number one is the most important, and that is the substantial threat of irreparable harm or injury to the movement. But the other three are whether or not the threatened injury to the movement outweighs the resulting harm to the respondent. Number three, the substantial likelihood that the movement will prevail on the remaining claims at trial. And then number four is whether or not the interlocutory injunction will disserve the public interest. I don't think that that's even at play here.
Right. I'm very familiar with those factors. We have to deal with them all the time. Obviously, I guess here's my question. I mean, you've already heard my comment about whether there is in fact a risk of irreparable harm if in fact Mr. Edelkind hasn't done anything in the last 2 years. Although I understand the expressed concern that perhaps there had been an intention to do so. Go ahead.
So, well, I think it's more important than that. I think what they're actually asking for is not to preserve the status quo, it's to change it. What they're really asking for is for Your Honor to basically freeze Mrs. Edelkind's easement rights, which already grant her the power to construct and maintain this retaining wall, for lack of a better word. And Your Honor saw the photos. They basically tore down this 35-something-year-old granite wall and built a completely non-conforming cement wall that looks nothing like it. I mean, Your Honor saw the photo where the two walls meet. My
Let me
client,
ask you, sorry to interrupt,
Sure.
Mr. Mayor, but
Go ahead, Judge.
I understand that this lawsuit only names Mr. Edelkind. Why, where is Miss Edelkind? And as the owner of the property, why am I not, why is everything I'm hearing about is Mr. Edelkind's interactions and not Miss Edelkind's interactions? Is there something I'm not aware of in the background here?
So there's no evidence before Your Honor
I
today.
understand. And I'm not asking for evidence. I just would like to understand why.
Sure. Well, and I mean, closing arguments aren't evidence anyway, but I can go ahead and
Sure.
tell Your Honor that the story behind the story is Mrs. Edelkind has basically, she's been suffering with dementia. She thinks she's going to marry Elon Musk,
That's
all
heartbreaking.
kinds of
I'm
things.
so
So
sorry.
Mr. Edelkind has to care for her constantly, and is sticking with her, taking care of her constantly. So he's currently actually involved in some proceedings to be appointed her conservator and legal guardian. Those are pending. They have not been final yet, but that's really what's going on. She doesn't really have a lot of interaction with these people. She's basically being cared for by Mr. Edelkind consistently.
I'm so sorry that
So
Mr.
yeah, that's
Edelkind
all
is
right.
having to deal with that.
And so, Your Honor, that kind of goes back to what I was saying. Ms. Edelkind has easement rights to maintain and build this wall. They built it to look historic. That granite rock has been there for decades, and it was torn down and replaced by this eyesore of a cement wall. Mrs. Edelkind has the easement rights, and that's undisputed, to do exactly what Mr. Edelkind wants to help her do. And so I would argue, Your Honor, that any type of restraining order that prevents them from doing that actually dissolves the status quo and basically puts a freeze on her property rights granted in the easement. And Your
Well,
Honor,
Mr. Edelkind is the only party here. Forgive me for interrupting, but I mean, at the outset, you pointed out, and I agree with you that if I impose any injunctive, order here, it is only going to direct and control the actions of Mr. Edelkind. And legally, Mr. Edelkind is able to act in multiple roles. And if Mr. Edelkind, as he is here before me now, he is here before me as himself, as someone who resides in that location. If he were to undertake some different action on behalf, or as in some legal capacity on behalf of Patricia Edelkind, that would be a different issue. And in the order that I entered would not attempt necessarily to reach out and grab that. If I were to enter, because I am most concerned about the interactions that have been alleged, and secondarily about the wall itself, if that makes sense. I understand your concern about whether that was properly pleaded or not, in the pleading that got us here, but I am very concerned about the nature of those interactions.
and I understand, Judge, just reading them would make me concerned if I didn't know anything about the parties. I mean, they're concerning on their face. But I would argue, Your Honor, that even when it comes to those allegations, the burden of proof is on the movement. And I don't believe that burden's been met. It's basically he said, she said. I mean, he
Well,
denies.
actually, it's he said, excuse me, it's he said, she said, but she has a witness who claims to have observed. And I understand there might be a connection between those individuals for purposes of weighing the credibility, but go ahead.
Yeah, and Your Honor, what's going to end up, I think, more likely than not
Hang on,
happening.
Mr. A. Hang on. I
My
know we've
fault.
been pretty informal, but it's technically still Mr. Merritt's closing
Understood.
argument, and you will get a rebuttal because you are the movement. And so we're going to let Mr. Merritt continue. Go ahead.
Okay, and I'll wrap this up quickly, Judge. When it comes to just what they actually pled, which is preventing him from doing anything to tear down the wall or rebuild the wall, the fact that any involvement he would have would necessarily be as the agent of his wife, who is the property owner and the easement holder. I just don't think that there is any grounds to enjoin him from doing it, and relying on having to explain to a peace officer that responds that, well, he's acting in a different capacity. I don't think that that's good enough, because if the whatever order you enter isn't clear enough and the officer thinks he's doing it just because he's communicating with a contractor because his wife isn't able to, for example, I don't want that to subject him to arrest for violating Your Honor's order. And when it comes to just the wall, and I'll address the other allegations, but I believe that a restraining order or an interlocutory injunction is expressly prohibited by OCGA 954 and 955. 954 prevents injunctions from enjoining trespass to property absent certain circumstances, and none of those are present in this case. 955
Well,
says,
most of the alleged incidents I've heard about Mr. Edelkin's unpleasant interactions, Mr. Edelkin wasn't trespassing, right? He was doing it from his side of the property or from the street or from the end of the driveway. So any order I entered would really be focused more on Mr. Edelkind's interactions, and that he
Okay.
not interact with others, not that he not come onto the property, because that would be covered by a different law.
okay, so if Your Honor is not considering an injunction that would prevent Mr. or Mrs. Edelkind from repairing the wall that they have easement rights to, because I do think that respectfully that would probably be error. When it comes to his interactions, he's denied that he's done all those things. I think that I think I can speak for Mr. Edelkind and say that he would be fine agreeing or being ordered not to spit on anyone or cuss anyone out. I don't think I think he's fine not having any interaction with these
Well,
people.
let me ask you this. I appreciate that. And I suspected as much, that at some point, really reasonable people ought to be able to get to, I deny I've done those things, but because I haven't done those things, I agree I won't ever do those things, right? That's a reasonable and easy thing to agree to. But that logic also extends to the wall, right? If there is this legal dispute, whether it's properly perfected in front of me in this lawsuit, if there is a dispute about this wall and where it is, why would we not agree to not undertake that course of action until that issue is resolved?
Well, there's two reasons, Judge. The first is I actually think that it's completely dissimilar and distinguishable from the interactions, because nobody has a right to harass, to spit at, or to assault another person. Nobody does. But in this case, there is a property right under the easement to construct and rebuild that wall. And additionally, Judge, OCGA
Right,
9.
But if Mr. Edelkind is wrong, and ultimately Ms. White's interest is vindicated, then you're looking at literal thousands, tens of thousands of dollars in damages for tearing down a wall that seems to have structurally, at least, provided the same benefit as the wall. I mean, and look, I get that is not in front of me right now. But when you're looking at an injunction, one of the things you are looking at is balancing the equities and trying to apply common sense to disagreeing parties that with incomplete information. And that is the one thing I don't understand is, if there is this dispute that Mr. Edelkind may believe he's fully justified in doing it, but that will almost certainly, based on what I'm hearing, result in further litigation, thousands of dollars worth of attorney's fees, and possibly thousands of dollars in damages for tearing down a wall that Mr. Edelkind didn't have the right to tear down, just as he asserts that Ms. White tore down a wall she didn't have the right to tear down.
Mhm.
Why would there not be an ability to agree not to do anything to the wall until we sort out that legal issue?
Okay, so I can answer that question. Number one, the General Assembly took that right away. That's the first reason. So if you look at OCGA 955, it deals exactly with this situation. And I'm going to quote, it says, equity will not interfere by injunction to restrain waste when the petitioner's title is not clear. Such relief shall be granted only when the title is free from dispute. In this exact type of situation, now is his behavior done at his peril if this order is not granted? Yes, but the law requires that, number one. And number two, Judge, you said that you made a comment about, like, well, if Miss White carries the day or prevails or something like that. Here's the thing. There's something that every person on this Zoom call today agrees with. It is not in dispute that Mrs. Edelkind has an easement, and that easement gives her the permanent right to construct and maintain that wall. Nobody disputes that. So where Mrs. White and her company tore down that 35-year-old granite wall, and rebuilt a cheaper cement wall in its place that doesn't match and is not in conformity with the remaining historical wall, nobody disagrees that I'm aware of that Mrs. Edelkind has the easement right to reconstruct or maintain that wall under the easement. I mean, Your Honor can take judicial notice. It's in the property records of this court. And any order that you enter hindering or restraining Mrs. Edelkind's rights under the easement would actually be destroying the status quo, not maintaining it. She's had the right to rebuild that wall, to maintain that wall, to construct a wall at her expense, unimpeded by any action of anyone else since 1987. The only thing that would stop her continuous rights under this easement for the last 35 or so years would be this injunctive relief, if it's granted. So again, the status quo, if the purpose of an interlocutory injunction is to maintain the status quo, then she already has the right. That is the status quo. She can reconstruct this wall because that's what the easement grants her the power to do. So if Your Honor is going to maintain the status quo, I think Your Honor should enforce those easement rights, not take them away until this lawsuit's over with, and force them to have to look at a wall that doesn't match the first half of the wall because it's not made of granite, it's made of cement, because the property next to it was excavated and led to the historical wall's collapse.
Thank you, Mr. Merritt. Mr. Ader, you get the last word.
Yes, I think it's important to look at the actual language of the easement because the idea of demolition and reconstruction is very different than what the actual easement grants. The easement grants agents, servants, employees, contractors, successors, and assign a non-exclusive easement, which is extremely important. Ms. White was entirely within her rights to rebuild the wall.
Let me interrupt you, Mr. Ader. Here's
Mhm.
what I understand about that easement. Number one, it is Mr. Edelkind is not a party to it. Neither is well, I guess Ms. White would have inherited those easement rights by per virtue of her company purchasing the property. But the other thing that I understand about that easement, and that was why I started by asking, what exactly is at issue in this lawsuit? Right? Because if we get rid of the quiet title because Ms. Edelkind is not a party, and we get rid of the easement issue because Ms. Edelkind is not a party, then what we are left with is a lawsuit about the wall. And I don't agree, Mr. Merritt, with your assertion of 955 and what it says I can or can't do, but his point is a valid one, which is that if I say Mr. Edelkind can't tear down that wall, then I'm functionally saying Ms. Edelkind can't tear down that wall, even though the easement is not at issue in this lawsuit.
So two things. And that's why I think the language of the easement is important. And Your Honor is correct in that 955 doesn't apply, specifically because the grant of easement states, and it closes in section 1, provided no waste is committed thereon, and the grantor's property is returned to its original condition. So I agree with you that 955 does not apply. Furthermore, the easement states that they can construct, install, maintain, upkeep, and repair, but it doesn't say that they can tear down a wall and rebuild it or do so when our client is in the process of selling. I also think it's incumbent upon the court to consider the other issues that Ms. White has faced. These are all connected to one another. It's very simple. The collapse of the wall is the central point in relationship sours. While Mr. Edelkind has testified, and I think likely we'll see follow-up litigation on the veracity of that testimony, that he has not cussed or done anything else. This is all part of one cohesive scheme. And the work on the wall is part of a kind of ongoing trend of harassment and delay. I have not yet had a chance to discuss with Mr. Merritt, but I have proposed to his associate and discussed on numerous occasions, let's have a very basic consent agreement as logical adults to not harass, to not scream, to not destroy, and to allow us to simply move on. If the court prevents them from destroying this wall as a means to help prevent the house, our client will be able to sell it in a matter of months. There is no harm. There is no balancing of issues because this wall, as they say, he doesn't like to look at it, it's an eyesore, but it's been there for 18 months and nothing has happened. We're simply asking the court for another 3 months or so our client can sell this without the wall being used as some kind of an intermediate way of essentially harassing or messing with our client and preventing them from selling the property. And that was the biggest thing in terms of getting the two parties apart, because regardless of what Mr. Edelkind says, We brought one witness today. We can produce another probably dozen as to his behavior over the last 18 months. And frankly, it's been evasive. There's been no good faith communication between attorneys or any attempt to curtail this behavior in an official way. So I have no understanding as to why that issue would be avoided outside of the fact that, hey, we want to be able to continue to flip her off. We want to be able to continue to use offensive racial or gender-based epithets to harass her and to prevent potential buyers from purchasing the property.
Mr. Merritt?
Yeah, I mean, all of that stuff was denied. That was a lot of entertaining.
Hey, nope, nope, nope. I was
Sorry.
asking a question. I was not inviting you to make further argument.
Okay.
So if Mr. Ader's request is 3 months, you're telling me that that's not something your client can agree to? That I won't tear down the wall for 3 months?
Well, first of all, I think really the issue, like Your Honor said, really the issue is, even
That's
though,
not my question. My question is not about the comment I made earlier. I understand the limitations here, that the easement is not technically part of this lawsuit because Miss Edelkind is not part of this lawsuit.
right,
But from a reasonable people perspective, you're telling me that Mr. Edelkind, even though he hasn't torn down that wall in 18 months, will not agree that, no, I will not take any action to take down that wall for the next 3 months.
I mean, I don't think I've spoken to him about that.
Okay.
I couldn't speak for
Do
him
you
on that.
think it would be valuable use of your time to try to speak to him about that?
I could try to speak with him about that. I think the bigger issue would be an infringement of Mrs. Edelkind's easement rights without her even being named as a party. And
I understand that, Mr. Merritt, but
yeah, I'm
again,
happy to talk to him about that,
I mean,
Judge.
I have the right to drive on any road I want to drive on, but I certainly am still allowed to say, you know what? I will agree, just so I can stop having this argument, that I'm not going to drive anywhere in my car that I'm legally allowed to own, where I'm legally allowed to be for the next 3 months. That's my question.
Yeah, I'm happy to talk to him about that.
Okay, Mr. Freehoff, will you please create a breakout room? Or if you're there physically with him, if y'all just want to take a break and go speak with him, I don't know. Mr. Merritt? Are you
Yes, sir.
able to speak with your client without benefit of a breakout room? I can give you one if you need
Oh,
one.
no, yeah, I can, if I can just turn off my camera.
Yeah,
and my-
absolutely. Just mute and take a break. It's 10:49. Let's
Okay.
maybe reconvene at 11, unless you need more time, in which case you can just let us know.
That should be enough time.
Okay, thank you.
Hi, Judge, we're back.
Thank you.
So I spoke with my client and he said he has no issue agreeing to wait 3 or 4 months and just leave the wall and the fence as they are to give Miss White and her company an opportunity to try to sell.
Okay. So thank you very much, Mr. Merritt, for talking with your client, and Mr. Edelkind for being willing to agree to that kind of limitation. So here is what I'm going to do. I'm going to ask the two of you to come up with some sort of consent that y'all would be comfortable with being filed. You can call it an injunction. You can call it a consent agreement. You can call it whatever you want. But there are really two things I want to accomplish. Number one, I think that big piece is if we were to agree on 3 to 4 months, right, then what we're talking about is, let's see, March, April, May. So we're talking about June. Let's say the 26th, which is a Friday, to make it a nice round time frame. So that in theory is what we're talking about. And I would say, or until Ms. ATL Spec sells the property, whichever happens first, when of course she no longer has any right to vindicate any ownership interest in that easement or the property. And then the second thing is, if there is agreement that we're not going to undertake changes by Mr. Edelkind to undertake changes to the wall, I would think that what's sauce for the goose is sauce for the gander. I don't think that Ms. White has any intention of doing that, but I'm just looking for something to avoid aggravating what is clearly already a highly charged emotional disagreement. And so basically what I would say is, let's all agree that we're not going to do anything relative to that wall between now and either June 26th or when Ms. White's company sells the property. And that in the meantime, if we're not doing that, then there's really no reason for these people to interact, right? And so that would really be what I would be looking for in a consent of some sort, or what I would order, is that the parties agree that they will avoid one another, not interact with one another, and not interact with stand-ins or agents, right? So so Mr. Edelkind's not going to interact with any real estate agents that are coming onto the property, or prospective purchasers, or otherwise interfere in Ms. White's ability to have people come on, prospective buyers. By the same token, again, if we're not messing with that fence, then I would not expect that anyone from ATL Spec or their real estate agents would need to interact with the Edelkinds in any manner. Is that something that the parties could live with for that 3 to 4 month period that we are talking about?
Yes, Your Honor. And I just thought about this. I don't think this will be an issue at all, but I would like just a minor exception, just if something does happen, if part of this wall does collapse again or something like that, I wouldn't want to be prevented from being able to like repair it or put the current wall back up or fix it or something. I don't know that that's going to be an issue.
Here's what, hang on, I'm going to save you the trouble, Mr. Eder. I understand that could happen. I understand it's unlikely, but that it could happen. And what I would say in an injunction is that not that someone could undertake emergency repairs, but that the parties agree to communicate through counsel if necessary in good faith to address if that happens, right? Not that Ms. White sees a problem, she can go fix it. Mr. Edelkind sees a problem, he can go fix it, because that starts to get real subjected really fast.
Right.
But that if Mr. Edelkind sees something, he can say, hey, Mr. Merritt, tell those people that the wall is falling down, there's a giant crack in it. Or same thing if Ms. White sees something, or a prospective buyer sees something. Hey, Mr. Eder, tell Mr. Merritt that you know, there's this problem. And so I would say there should be some language, you lawyers can lawyer it better than I'm doing in the heat of the moment just now, but something about good faith consultation if something were to come up that would require someone to do anything to that fence.
Yeah, that'd be fine. I can work with Mr. Eater if something like that happens, and hopefully it doesn't.
Okay.
I'm sure we can come up with language to address that contingency.
Okay, so to be clear, even though there is not going to be a written order in place at the end of this hearing, I do want to be clear that that is going to be what the parties have agreed to, and the court expects the parties to conduct themselves that way, as if there were a written order in place until we can get a written agreement in place. Today is Tuesday. Is it unreasonable to ask for it by Friday?
Not at all.
Okay.
I have another hearing at noon, but I can even this evening try to get a draft out.
Okay, thank you. And not a super rush. I don't need it today, but just by Friday, if that's not too much of a rush with what else you have going on, I think that would be reasonable.
That's fine. And we can make it effective nunc pro tunc as of
Yes.
right now.
Yes,
great.
that would
Okay.
be very helpful. I
Okay.
really appreciate y'all's efforts to distill this down. And I will hope that everybody can move forward, because here's what I foresee happening, right? What I foresee happening is that ATL is going to sell the property, and then hopefully it will not be the new owner's problem, but it will be the new owner's problem, right? Hopefully there will not be a problem, but it will
Right.
be up to that new owner to decide. And so at the point at which ATL sells its interest in the property, then this lawsuit would necessarily go away, so long as Mr. Edelkind continues to abide by not interacting with ATL and its, you know, agents, et cetera. So that's kind of what I'm foreseeing. And then we can figure out if there's something down the road that we have to, if it goes longer, that we have to deal with the easement. Okay.
Okay.
Thank you all. Have a good day.
Thank
Thank you,
Your Honor.
Judge.